Famous personalities and the creators of well-known characters may come to learn that businesses are using their name or characters to promote their goods and services without the consent or authorization of the personality or character producer. Where there is no agreement or contract permitting the use of a personality or character for marketing purposes, the tort of passing off can protect their interests. There are two forms of passing off: classical passing off and extended passing off. Classical passing off protects trading goodwill or reputation, which includes situations where a trader tries to pass off their goods or services as being those of another party. Extended passing off protects promotional goodwill, which is the proprietary interest a party has. Extended passing off protects the innocent party, where a trader makes a representation that their product or service has some association with a personality or character, for example through licenses or permits. This can skyrocket sales due to the level of influence exerted by public figures. Passing off protects the party's property through their goodwill and not the goods or services themselves. The plaintiff's goodwill must be injured by the defendant's acts. In order for an action in passing off to succeed, the plaintiff needs to establish its three elements known as the classical trinity. Firstly, the plaintiff needs to establish that they have attained a reputation or goodwill in trade or business through their name, goods, services, and marks. Defamation protects the private reputations of individuals, however passing off does not. In establishing goodwill, the courts in Australia do not require that there be a common field of activity between the parties. In Henderson and Radio Corporation, two famous ballroom dancers were able to restrain the other party from using their photograph as the cover of a dance music record. It was irrelevant that they were in completely unrelated businesses. The second element provides that the defendant needs to have made a misrepresentation to the effect of deceiving the public, or a representation that causes confusion as to whether the plaintiff is involved in the defendant's business. In the case of Children's Television Workshop Incorporated and Woolworths, New South Wales, the producers of Sesame Street had the right to grant licenses for the production of the Muppets merchandise. Meanwhile, Woolworths produced and sold plush toys, which looked like the Muppets characters. The court found that the public would be inclined to believe that Sesame Street was associated with Woolworths, as the public associates the marketable commercial goods with the party who has the authority to permit their manufacture. In the case of personalities, the person must be unequivocally identified, either through the use of their name, photograph, or other information particular to them, which causes confusion in the public's mind. It is irrelevant whether the defendant had an intention to misrepresent the source or affiliations of their goods or services. The final element is that the representation made needs to have either caused actual damage to the plaintiff's goodwill, or there is a probability that the plaintiff will suffer damage if a quia timet action is brought. The types of damages that may be pleaded include diversion of trade, devaluation of reputation, confusion and loss of control, dilution, submerging, swamping, and restriction on expansion potential. The plaintiff can seek damages or an injunction to restrain the defendant's activities in a quia timet action.